Good evening, everyone. As I said from my intro, those of you who have looked at it, tonight I'm looking at employment law. It's amazing. We are in the third quarter of the year, and then we have a new Prime Minister. And I'm sure that within a matter of time, we are going to experience a lot of changes. But hey, the law still remains the same. So tonight is another opportunity for us, City Law Solicitors, to look at the law. And as I said from the previous week, we are getting deeper into the law. This is the platform where we teach law. Tonight, I'm going to look at something very distinct, and it's quite deep. And I do some of these programs because of the challenges and the difficulties people go through at the workplace, just because they don't know their rights. There are a lot of laws that protect people at the workplace, especially those who are vulnerable or those who are associated with certain people who have vulnerabilities. And tonight I'm going to take my time gradually to explore and to explain to viewers how one who is not a disabled, who is not pregnant, who in fact may not have certain religious belief, or who may even have a girlfriend who is white or black with different colors, how they can claim discrimination by their association with any of these parties who has protected characteristics. And I'm going to take my time to gradually explain some of these things, because I know that I need to be very mindful of my choice of words, because being legalistic will make it quite difficult for viewers to understand me. But what I'm trying to do tonight, from a layman point of view, is saying that if you are claiming for discrimination at the workplace, sometimes it's not because of your own personal characteristics, such as whether you have disability, or such as whether you are pregnant, or such as whether you have a certain political belief or religious belief. But in fact, by your association with somebody who have these characteristics that I have just mentioned, and if you suffer any less favorable treatment, the word here is less favorable treatment. It means that there is what we call a comparator, where one person is treated less favorably because of that person's association with another person who has a disability, or with another person who is pregnant, or with another person who has a particular religious belief or political opinion, and the employer doesn't like it. Or, for example, those who may be entitled to what they call reasonable adjustment under the Equality Act, Section 20. This is what I'm going to take my time to explain. And then, obviously, I will also explain how people can claim compensation, because there is no point explaining all these things if it's of no benefit to viewers tonight. And that's why I'm urging you tonight to join me and share the video so that your friends and family members, I know some of you who've been calling me and having all kinds of issues at the workplace, you are the one that's supposed to watch some of this program, because obviously when you know you are right at the workplace, you probably wouldn't even call me again to ask questions, because I have given you all the information that you need. But that notwithstanding, I am still here to fulfill city law's corporate social responsibility by bringing the law to your doorstep, by making law very affordable. This program is about you or that friend or that family member. It's about giving you opportunity for you to ask a question, that question that has been lingering in your mind, free of charge. It's about helping you to know you are right, either because you have immigration problem or because you have a problem at the workplace. That is why I'm here tonight. And I believe that most of you are going to remain with me throughout this program, which is going to take me about 30 to 45 minutes to come to the end of it. So tonight, if you checked the Facebook page, you see the topic there. It's quite clear what I'm going to do tonight. There is no doubt that it's going to be beneficial to most of you. But before I do that, I want to give you the opportunity to prepare yourself and get ready. And obviously, when I come back after this short commercial break, which my sponsors, CITI Law Solicitors, have instructed me to take so that you guys can see what CITI Law Solicitors does. And all the areas of law. One time someone was telling me, well, I thought you guys do only immigration. No, we do civil litigation, we do employment law, we do family law, we do all kinds of law. And we are well versed in all these areas of law. So as I go on this short commercial break, it's an opportunity for you to see what we do. And when I come back, I give you free legal advice. Thank you. Don't go away. And please share the video as I go on this short commercial break. thank you for your patience. I'm back. Yes, tonight we are doing employment law. We are in the third quarter of the year. Isn't it amazing that God has protected all of us to bring us this far? We're in September. Within the next 3 months, there will be Christmas, and then we enter 2023. And quite surprisingly, we have a new Prime Minister from yesterday. So there are a lot of changes taking place in this third quarter of the year. But one thing that remains the same is the law, which CITI Law Solicitors brings to you every Tuesday and Thursdays. And on Tuesdays, we do this program in English for those of you who have joined us for the first time. And then on Thursdays, we do it in Chi. Tonight, I'm going to teach something which is quite deep. And the reason I say that is because I'm looking at employment law, specifically the Equality Act 2010. But I'm going to talk about something quite distinct in the sense that you hardly hear people talk about it, and most people are not aware of this. But I bring this to you because of CITI Law Sources, who are sponsoring this program. We are always making sure that we fulfill our corporate social responsibility by bringing these good tidings to viewers. So there's no doubt, and you agree with me, that all of us at one point or the other face challenges at the workplace. It's not because employers are wicked. Sometimes employers themselves don't even know the law. Yes, because we go to tribunal and we find out that some of them start shivering as soon as there is a claim lodged, because they suddenly find out that they've made mistakes. And therefore, it is for you as an employee to know you are right at the workplace, so that you can even direct or guide the employer not to either victimize you, bully you, or discriminate against you by treating you less favorably because of certain protected characteristics. And as I was saying, normally all of us are familiar that there is what we call discrimination. All these things comes under the Equality Act 2010. And sometimes you all know that if, for example, somebody has been sick for a year or more, that person becomes disabled if he's in work. And then he's entitled to what they call reasonable adjustment under Section 20 of the Equality Act. So, and there is what they call direct discrimination. So we have direct discrimination under Section 13, and then we have indirect discrimination under Section 19. I don't want to bore you with these laws, but I want to be sure that you understand the facts that I'm quoting, because I'm not here to throw dust into people's eyes. I don't speak fiction, I speak facts. So if you look critically, the Equality Act Section 13, the definition there says that the person or B should not treat A less favorably because of protected characteristics. And normally when we say protected characteristics, we are looking at people who have disability, who because of their religion, because of their race. If you are black and white, we have differential treatment. People who are married, people who even are older, age discrimination, people with some sexual orientation, gay, lesbians. So the law protects all these protected characteristics. And if you look critically at the Equality Act Section 13, one, it states that B should not treat A less favorably because of protected characteristics. You find out that this is English. This evening somebody was saying that the new Prime Minister, instead of using the right grammar, aspirational country, he said aspirational country, which is wrong. But that's not why I'm here tonight. So this English is quite important. So it means that you watching me tonight can claim discrimination because you've been treated less favorably because of protected characteristics. But that protected characteristics, you don't possess it personally. What it means is that, for example, you may have a child who is disabled. You may have a mother who is disabled. You may have a wife who is disabled. You may have a daughter. You may have a father who is disabled. All these people have what they call protected characteristics. And they may live in your household. But one thing is that in most cases, you may want to get flexible hours of work so that sometimes you can cater for some of these people in the household, because obviously sometimes your employer may want you to do overtime, whilst at the same time you want to go home and look after your sick mother because she's disabled, or you live with your father who is disabled, or you have a disabled son at home, or even a disabled wife at home. And the employer, in most cases, out of erroneous belief or not being aware of the law, and you are right at the workplace, may sometimes restrict you from enjoying that flexibility, which is allowed under Section 20 of the Equality Act. So this is what they call associative discrimination. Now, so when we talk about associative discrimination, it means that you don't possess that characteristics yourself. You are not disabled yourself, but you are associated with somebody who has disability. So that becomes associative discrimination, where the employer treating you less favorably or not giving you what they call reasonable adjustment because the employer feels that you don't have that characteristics. But in fact, your son, daughter, or mother, or father has that disability. And in fact, you are associated with that person because, for example, you have a duty to look after them. And there are numerous cases. I don't want to bore you with case laws, but there are cases where, even with NatWest, most recent case, somebody who works for them as a banker had a disabled child and therefore needed most times to have time off or to work from home to look after that person. And when they decided to make people redundant, they decided to select him to make him redundant. Why? Because he wants to work from home because of a disabled child. Or for example, he wants to even get more time off sometimes to take the son for hospital appointments. And the employer didn't like it. But of course, in most cases, it's not because the employer is wicked, because they are not aware that under Section 13, even if you are not disabled and you are associated with somebody who has disability, then by default of the fact that you have association with that person, you are entitled to be treated just like anybody who has disability and employed by that employer. So you find out that sometimes it's quite frustrating for some of these carers. And when I say carers, people who are working and have disabled people to look after. So where, for example, they are meant to be offered what they call reasonable adjustment to enable them to have that flexibility and look after these disabled people who are in their care, and they are deprived of that right, then it means that they are being treated less favorably because of a protected characteristics. And that protected characteristics means that that person who is disabled in their household, and that also means that because of the association with that person, because obviously they have a duty to care for that person. So that is looking at the Equality Act under Section 13 when we are looking at what they call direct discrimination in relation to you having a disabled person in your care. But having said that, The other point that is also so significant here is, for example, those of you who may have either your wives falling pregnant. And most times, we all know that when a wife falls pregnant, or a girlfriend or partner falls pregnant, there are times that they have to, because of the prenatal care, they may have to have a couple of hospital appointments. And sometimes some of these appointments, because they are so frail, you as the partner or the husband or the cohabitee with that person may have to even drive them and then get time off from work so that you can cater for your pregnant wife or pregnant partner. And in most cases, I'm not surprised that most of you watching me will agree that employers will blatantly refuse to give you that reasonable adjustment for you to undertake that duty, which is so dear to you, by looking after or sometimes driving your wife to the hospital. Now, so under those circumstances, if you look at, again, the Equality Act, I'm taking you back to the section 13, where it says that A should not treat B less favorably because of protected characteristics. I have already defined what a protected characteristic is, which is somebody who is pregnant or on maternity, disabled or race. All these falls under the protected characteristics. So under these circumstances, if you are deprived that opportunity to look after your girlfriend who is pregnant or your wife who is pregnant, because the employer feels that you don't have any right to get that time off, then that becomes unlawful and a breach of the Equality Act under Section 13. Now, so having given these two scenarios, going deep into this, you find out that it's not just ordinary employers. There is a case where even the DWP was involved in the case of McCroy, where this gentleman had a sick father in the household and therefore needed some time off during particular time of the year to look after the sick father because he was disabled. And the DWP refused that. And the employment tribunal held that by obviously refusing to offer that adjustment, knowing well that he is associated with a disabled person in the household, being his father, that is a breach of the Equality Act under Section 13. So you find out that from the point I'm driving at, in most cases, you might not possess that protected characteristics or be disabled yourself or be pregnant yourself or have a particular religious belief yourself, but rather because you are connected with someone else who has it, then you could be subjected to what they call unfavorable treatment. Unfavorable treatment occurs where, for example, you are treated less favorably compared to other persons or hypothetical person who would have not possessed that characteristics or would have not been in your situation. Now, so that is to do with the Equality Act under Section 13. I'm going to acknowledge my viewers and then I'm going to look at victimization and bullying under Section 26 and then 27 of the Equality Act. So I want to acknowledge all of you who are here tonight. It's always a privilege to be here because, as I've said, I'm just surprised that today is the 6th of September. I still remember January when the weather was good and the weather has just changed. It just feels the same. And we are in the third quarter of the year. So many things has happened. So very soon we're just going to get to the end of the year in less than 3 months' time. Tonight, and obviously there are people who have always been part of this show each time we are here. Please, if you are watching tonight, I want you to put a comment so that I can acknowledge you. I value those of you who always join us. For us to have this show, it's freely advised, but it's well deserving. I have Ernestina Kakari, said good evening. I have Tika Opait West. Hey everyone who is also watching. I have Asiama Francis. I have Winfred Chate Annan, who are also watching. I have YK Francis watching. It's a nice program. I have Inchi Opa watching. Highly favored Priscilla watching. I have Esinam Afi Kasa, who is watching. I have Ebenezer Amponsa. It's a good job done. I have Jonathan Lai. Wow, Jonathan, you are here tonight. Well done. I have Fred Asare, who is also watching. Also, thanks for the free education. I have Pa Kofi Pizarro, who is also watching. He's also been a regular member of the team. So, guys, tonight I'm looking at employment law. I know that most times we take some of these things for granted, but I understand the frustration that some people may go through when they find themselves in some of these circumstances. And because of that, they get distressed, they get frustrated, and in fact, it could be very, very, very stressful for a lot of you. And obviously, I am here to enlighten you about your right. I am here to make you aware that there is a protection within the law. But you need to know that right so that you can assert it. And sometimes, as I've said earlier, it's not because that employer is wicked. It's because that employer might not even know the law himself or herself. So I have looked at this Equality Act, Section 13. I have looked at treating someone being treated less favorably because of protected characteristics, which means that it doesn't personalize it. This is English. It means that if I say that I'm associated with somebody who has disability and therefore I need time off to care for that person and I'm refused that time off, then it means that I'm just like a disabled person at the workplace who would have also been given time off for one reason or the other, or who would have been offered what they call reasonable adjustment under Section 20 of the Equality Act. And therefore, if one is deprived of this, and that person can demonstrate or prove that he has an association with another person who has the protected characteristics or disabled or pregnant or have a religious belief or because of race. Just imagine a black person sometimes going out with their white girlfriend and being subjected to an abuse because of that association. And most people don't know that the other party who have not even been subjected to that abuse has a right to claim for discrimination because of his association with the other party, because of that person's color. These are hidden secrets in the law that I'm trying to expose to viewers tonight. So if you have just joined me, I've looked at those who have disabled person in their household by looking at the Equality Act, Section 13. I've looked at those who may have a pregnant person. Last time I looked at Equality Act Section 18 by looking at those who have maternity leave or pregnant, and the reasonable adjustments that they are entitled to. So at this point, I'm going to look at what they call harassment and then victimization. All these are within the Equality Act. And most times when people are feeling harassed at the workplace, if you look at Section 26 of the Equality Act, it makes it clear that if, because of protected characteristics, one is either humiliated, he suffers, he's harassed, or he receives unwanted conduct, or unwanted utterances are made to that person, or whether because of that person protected characteristics he suffers his dignity, or words are said to him that affects that person's dignity, then that is harassment. But of course, the underlying, sometimes there was a time that we had a case, and the lady made all kinds of claims, and he said that she's been harassed at work, and then she also said that she has suffered less favorable treatment because the job he applied for has been given to another person, and then he's being taunted at the workplace and all that. And he had made all these spurious claims, and she felt quite aggrieved and very angry. And I took my time when she came for consultation. I took my time to explain everything to her and made her aware that she didn't have a case because, one, the person that the job had been offered to, my understanding from what I heard from her, is also a black African just like her. So in this case, you are from the same ethnic background, you are of the same race, and in fact, the employer was to argue that he's more qualified than you, then on what basis are you going to claim that you've been treated less favorably or you have suffered discrimination? And then he felt that he was being taunted because he's lost the job, and therefore he felt he was being harassed. But remember, harassment needs to be built on the basis of a protected characteristics. So for example, one of the cases that we are currently dealing with, where the black guy had been subjected to quite some numerous abuse from a white person, then in that case, if he's saying he has suffered harassment, then he could reasonably argue that it's because of his color, race under Section 9. So in this case, there is a case of harassment on the basis that there is what they call protected characteristics. So viewers should be quite mindful how they sometimes make some of these spurious complaints that does not hold water because they have no basis in law. But having said that, I'm taking my time to explain this harassment at the workplace. So for example, if because of your association with another person who has disability, and if, for example, you need this time off, or you are treated less favorably, and you feel that you've been subject to inhumane treatment because of the fact that maybe you need time off, then in this case, because of your association, so in this case, you realize that you might not make a case on the basis of your color or race, but you might make a case on the basis of your association with another person. And on that basis, you could reasonably argue that you have suffered harassment in breach of the Section 26 of the Equality Act. But having said that, there are some of you, I know very well that sometimes when one has suffered discrimination at a workplace, and then you are looking for people to assist you who have even witnessed, because one of the cases that we are doing quite recently, the gentleman has witnessed this abuse. He saw everything that happened. The guy has made a complaint, but he has refused to witness in favor of this claimant simply because he feels that he is going to be dismissed, or he might suffer what they call a detriment at the workplace because of giving a support, genuine support to somebody who has suffered abuse or discrimination at the workplace. Now, so if you look at the section 27 of the Equality Act, it makes it clear that if you have assisted somebody who have suffered discrimination or who has a protected characteristics, or even campaign against, for example, discrimination at the workplace, that means that in this case you are claiming that you have an association with people who are being treated less favorably. And therefore, if for that reason you are victimized, which falls under the Equality Act, then you have two sets of claims or grounds for making a case. And I know that there is a case with that where the gentleman was arguing as a trade union member that some of her colleagues or his colleagues were receiving less pay compared to their white colleagues. And as a result of that, he was dismissed. Now, that in itself means that because he's making a campaign against discrimination at the workplace, that makes it victimization. And the fact that he's also connected with those who are being treated less favorably, again, it becomes a protected characteristic by association, which also makes it discrimination or breach of the Equality Act under section 27. So tonight I have looked at how one can obviously claim discrimination or breach of the Equality Act if that person does not possess, personally possess that protected characteristics enlisted under the Equality Act, such as race, religion, disability, pregnancy and maternity, sexual orientation, religious belief. So all these characteristics are features that people may possess, but I have, in one way or the other, taken my time to explain that if you have association with any of these people who have these characteristics, then even if you don't have it at all personally, you could say claim a breach of the equality or discrimination at the workplace by association. So I always love to explain further after I have explained the breach or the basis of arguing for breach of the law and what compensation you are entitled to. Now, when it comes to the breach of the Equality Act, this is the only area of the employment law where you could still remain in employment and say claim compensation. Now, in most cases, normally when people are making effort to claim, for example, unfair dismissal and claim compensation for unfair dismissal, they need to have been dismissed from work. So let's say if you have been dismissed and you have worked with the employer for more than 2 years and you are saying that your dismissal is unfair because, well, maybe they did not conduct proper investigation, or maybe the investigation was biased, that the same manager conducted that investigation and also made decision to dismiss you, then that in itself means that the ACAS Code of Conduct has been breached, or where you've been dismissed, not having done anything in breach of your own contract of employment. That might also be unfair dismissal. But for you to claim unfair dismissal, you need to have been working for 2 years or more. So you see that with dismissal, unfair dismissal claims for compensation, you need to have left your employment. However, when it comes to breach of the Equality Act or discrimination, sometimes you can still remain in employment and still claim compensation. And let me explain why you can do that. Because when you are looking at a breach of the Equality Act, for example, where you are saying that you have been treated less favorably because of your association with somebody who is a disabled person, then it means that by your association with that disabled person, being it either your girlfriend, your son, your daughter, uncle, father, mother, but that associative discrimination, it means that you have suffered what they call injury to feelings. And by that alone, if you're able to provide medical evidence, then we have what they call the Vento guidelines, which start from £9,000 onwards. So you are still in employment, but because of that breach of the Equality Act, because of associated discrimination, which I've just explained, then you will be entitled to compensation for injury to feelings. However, if for whatever reason that unfavorable treatment resulted in your dismissal, bringing your contract to an end, contract of employment to an end, then in this case, you are not only claiming what they call injury to feelings, but you're also claiming further compensation in terms of loss of earnings and future loss of earnings. So you see that at this point, I've taken my time to explain that whenever there has been a breach of the Equality Act by associated discrimination or associative discrimination, one will be entitled to compensation due to injury to feelings. And if there is a dismissal, there is further compensation for loss of earnings. So I have Patricia Opoku who have just joined us. Patricia, thank you so much for joining us tonight. So tonight it's been a privilege to take my time to explain associative discrimination, where you can claim discrimination even when you don't possess that particular characteristics. And I've already explained that that particular characteristics or protected characteristics is where one is disabled because of one's religious belief, because of one's sexual orientation, because of one's race or color or ethnic background, because of one's age. Some people, because they've getting to a certain age, whenever they apply for any job, they don't offer them chance. That is discrimination in some circumstances. So I have explained that with the exception of marriage and age discrimination, any of these things that I've explained, if by association, that is, you are connected to any one of them, and you are deprived of any opportunity, for example, to provide care to them, those who are in your care, then this could amount to a breach of the Equality Act, and you will be entitled, obviously, to what they call injury to feelings compensation, even if you are still in employment. At this point, I'm going to open the phone lines, and if anybody has questions, either on what I have discussed tonight, or any other question that falls within my area of practice, jurisdiction, and competence, I'll be willing to answer that question. So I'm going to open the phone lines, and if anybody has a question, this is an opportunity for that person to get free legal advice. So whilst waiting for people to phone in, I'm going to advertise CITI Law Solicitors, because CITI Law Solicitors is the sponsor of this show. This free legal advice being brought to you is proudly sponsored by CITI Law Solicitors. So the phone lines are on the screen. If you look at the screen, you see that the phone lines are there. But if for whatever reason you've not noticed it, the phone lines are, the studio lines to be precise, are 0793 293 4518. That's one of the numbers. I repeat, 0793 293 4518. And then we also have 0744 033 8623. We have 0744 033 8623. Those are the studio lines for tonight. I notice that sometimes after I have left studio, people still call and send messages. No. If you want to call after we have left the studio, then this is the number to call, our office number. So when I've left the studio and you have any queries, further queries, you can call the office number, which is 020-3355-0782. This is our office number. Those of you who, one reason or the other, sometimes call my mobile, and for one reason or the other, I'm unable to answer, please don't be perturbed. Note down the office number, because we have a team of solicitors who are hardworking, who are very caring and very competent, and are willing to assist you. So if you take the phone number, you can always reach out to us and we'll be willing to assist. 020-3355-0782. That is the number to call, the office number. Now, if you want to visit us or come to our office, those of you who may want to come may have private matters, or you want your matter to remain private and confidential, and therefore you want to come to the office for consultation. Now, if you are coming to the office by train, we have the District line to Barking, or Hammersmith and City line to Barking. And then those of you coming from North London, we have the National Rail from South Tottenham, coming all the way from Gospel Oak to Barking. So we have, and then those of you coming from, I have some clients coming from Basildon, South and Sea, Pitsea, Renham. All of you, you can also join the C2C and then come to Barking. Now, if you get to Barking, this is where to find us. Once you've gotten to the Barking station, once you come out of the station, you turn right. There used to be Santander Bank there. I understand it's closed now, but they say KFC there. If you're hungry, you get in there, have some chicken. Don't cross the zebra crossing. Once you get to the zebra crossing, you turn right. So from the station, you turn right, and then you turn right again by the zebra crossing. You walk for literally less than 2 minutes, and then you see the traffic light. That's where you can find Barking Enterprise Center. Our office address is Unit 113122, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 118FG. That's where you can find us. So that is our office address. Now, at this point, I'm going to also announce the areas of specialization, the areas that one time somebody was telling me, oh, I thought you guys do only immigration. No, we practice in numerous areas of law. We do immigration, that's one of our specialty, immigration law. Those of you who want to get sponsorship licenses for your businesses, if you own a care company, we've done numerous licenses for these companies who are bringing people from Ghana and all over the world to assist them in providing care to their clients. So if you want us to apply for a license for you, we can also do that. We also do application for those who want to bring their spouse, their children. Last time we did a program on how to even bring your child if you have limited leave to remain. British nationality law, if you want to naturalize or register your child to become British, we practice in all these areas. Those of you who want to seek asylum, we do all these areas of law under the city law, immigration department, employment law, which is what I've taken my time to explain tonight. We specialize in employment law. If you have been unfairly dismissed, we can assist you to get compensation. Family law. We are family law accredited. I want viewers to understand the distinction. We are not just solicitors. We are family law accredited. It means that we are at the peak of the practice with special accreditation. And therefore, if you have a family law matter, if you are going through divorce and then you want a lawyer to deal with your matrimonial asset so that you can get equitable share of the matrimonial pot. This is where to come to. If, for example, you don't have contact with your child or your children and you want to have child arrangement order in place, some of you even need this in order to renew your immigration status because you've been deprived of that physical contact and therefore you soon become illegal. There is a way out. We will assist you to get child arrangement order in place so that you can have contact and be involved, actively involved. It is in the best interest of children for both parents to be involved in their upbringing. And the family law have taken cognizance of that. So don't be deprived of that opportunity of being involved in your children's life. We can assist you to have child arrangement order in place so that you can be seeing your children. If there is non-molestation order against you or occupation application against you, we can also assist you to defend it. If there is an abuser or perpetrator who is subjecting you to harassment and abuse at the home, we can also assist you to put in application for occupation order to exclude that person from occupation, to remove that person from home. Again, we also specialize in personal injury and clinical negligence, and here we specialize in these areas for those who have had accident at work, please, those who are driving and are involved in accident and want to claim compensation for their injuries. We do these cases on no fee basis. Commercial disputes and civil litigation. If your company is owning you, if you have sought to buy some products from a company, they have taken deposit from you, they have failed to deliver. Recently, a potential client called me and then he said that he wanted to buy some stuff and he paid some deposit, and when he came he found out that that was not what he needed. And the company is saying that, well, because we have kept this product for you for such a long, we have lost sales and therefore your deposit is lost. And I said to him, this is a breach of Consumer Rights Act, because the good is not just as described, it is not fit for your purpose, and probably not of satisfactory quality. That in itself is a breach, and you are entitled to your deposit, because the good should follow the description because you told them what you needed. So if they cannot fulfill that description, then it's a breach of your consumer right. Now, so under our commercial dispute and civil litigation, if you have a company owning you, or you are being owned by a company and they have refused to pay, there is a dispute between you, or you have a company and you want to put in place proper documents that you can have shareholder agreement in place, you can have directors agreement in place. Look, day in, day out, we are coming across these cases where people are dragging themselves to court because they have failed to put some of these things in place. And sometimes it can be very devastating. The whole world that has been acquired can be just evaporated simply because you didn't consult a lawyer to assist you in putting in place some of these things that will protect you when there is dispute. This is the service that City Law Solicitors provides to you. It is a one-stop center. All your legal needs can be met. So at this point, I want to thank all of you who have been part of this show. And before I go, I want to acknowledge those of you who have joined us at the end, coming to the end of this show. I have Williams Opoku. We have Kuku, who is watching, our senior cook, who is our Facebook promoter. I have Ben Osei, who is also a manager, who is also watching. I have Frederick Green. Oh, Mr. Frederick Green, how are you? Thank you so much for joining us tonight. So tonight I have taken my time I'm coming to the end of the show. That is when most of the viewers are coming. Now, if for whatever reason you've missed part of this show that I've had tonight, I want to say that if you have missed any part of this program, or you find it very, very interesting or very insightful and educative, this program remains on the CITI Media platform. It is there. You can watch it again and again and again. And on Thursday, we are going to have the same program, which will be hosted by MC Chaka in Tree from 9 p.m. onwards. So I want to urge all of you again to join us. It's going to be amazing. I will take my time to explain most of these things in Tree language for all our family members in the diaspora. This is where we teach the law. Tonight I have taken my time to teach viewers or to explain to viewers what they call associative discrimination. That is, or associative discrimination, that's when one receives unfavorable treatment even if that person is not disabled or that person is not pregnant. So sometimes you may need time to assist your wife or your girlfriend because she's pregnant. Remember, pregnant women are protected under the Equality Act, under Section 18 of the Equality Act. So it means that that protection extends to you by association. You don't have that protected answers. If you have a disabled child, your father, your girlfriend, your mother, who lives in your household, then you are entitled to what they call reasonable adjustment under Section 20 by extension because of your association with that person. That is what I've taken my time to explain tonight to viewers. It's been amazing to have all of you on board, and I wish God blessing upon you. This is where I draw the curtain to the show. Thank you, and God bless you.